This lecture focuses on the historical evolution of international law and on some of the key elements of the international legal system. This will go in hand with the next lecture, which focuses on the United Nations and on the ways in which international law has become institutionalized. By the end of this unit, you should have a good knowledge of how international law came to be what it is today, along with some of the differences in interpretation given to it by realists and liberals. The backstory here involves a long and fairly complicated transition from natural to positive law. We've mentioned Hobbes very briefly in this course before, but for scholars like Hobbes, Thomas Hobbes, and Hugo Grotius, they were writing in what we refer to as the natural law tradition, which tends to emphasize a few key points. The first, that people have an inherent nature, such as a tendency towards war or violence, as you can see in the quotation from Hobbes on the right of the screen. Second, that it is the duty of legal scholars to discover that nature, and to establish principles to best control and manage it for the good of all. The trick to the game is to correctly assess and identify what that human nature is, a task that involves writing lots of philosophy and lots of introspection. Once you have figured out this nature, it's really non-negotiable. And third, international law therefore needs to manage this nature, both to best govern human affairs and to show fealty towards God. And one of the points that the textbook brings out very clearly is the ways in which people's ideas about human nature and about law were also tied to their ideas about the divine and about religion. Well, this gives you a quick overview of what natural law is really all about and the ways in which people understand the world through these principles. By the 19th century, this of course is all but changing. The shift to positive law requires seeing law not as something given by our natures or by God, but as something created by people and that we can perfect for our own ends and goals. Your textbook outlines 4 characteristics of modern international law, and you should of course read through these very carefully. Multilateralism only really begins in the 19th and 20th centuries, with the aftermath of the Napoleonic Wars and the Concert of Europe, which we mentioned earlier. Consent is obviously important, but is complicated by the fact that governments are bound by the principle of legal personality, to follow laws and norms that they themselves didn't consent to, just as individual people follow laws that were in place long before we were born. As an example of legal personality, when a government in a given country changes, that new government can't rewrite all the international treaties that have been consented to by prior governments. You're bound by them, even if you, as a government, don't like them. The principle guiding this is called legal personality, because even though the government has changed, the legal personality of the state has not. The language and practice of justification, along with questions of institutional autonomy, round out the list and are pretty well described in the relevant pages of your text. It follows, though, that much international law is focused on statist principles. As discussed in the chapter on the UN Charter is really a document that privileges the rights and responsibilities of state actors, with restrictions on what states may or may not do. The Geneva Convention on Refugees is one example of this, and it's an example I like to use because I wrote my master's thesis on it. It puts into place a lot of restrictions on what states may or may not do to refugees. It does not really give refugees many rights at all, and many treaties and many international legal instruments are pretty much like this. On top of that, we get another series of ways in which a statist idea of international law is normalized in this period of time. Borders, for example, are sacrosanct, and this is pretty much spelled out in the UN Charter. Generally speaking, international law until the 1970s is focused much more on maintaining peace and stability based on respect for borders and territorial integrity, and not so much on the rights of individual human beings. Well, this is all going to start to change in the 70s and 80s. I've given you a few key reasons here on the slide as to where the change comes from and how it works, but you can start to see some of the details coming forward here. First of all, the insistence on human rights law and the growing place of human rights law in what we call international law as a whole. We tend to think very naturally today of human rights law as being very important, except that for a long time it really wasn't very important. The Universal Declaration of Human Rights, drafted in 1945, is in fact what is called soft law. It's a declaration. It includes words like will try to and will undertake to, whereas treaties and conventions are hard law. They include words like shall and must and will. Well, the Universal Declaration of Human Rights is a declaration which gives you some idea as to how seriously human rights were being taken in 1945, right at the very, very beginning of the Cold War order. The Convention on Racial Discrimination, the Convention Against Torture, the creation of the UNCHR are all referred to in your textbook as parts of human rights law, as are individual efforts to govern human rights more actively and aggressively. For example, the arrest of Augusto Pinochet, the former Chilean dictator in the 1990s, really put forward the idea that human rights can be actively used to apprehend and to put on trial people who have committed human rights abuses. Second, the importance of non-state actors, the international campaign to ban landmines, the Red Cross for a much longer period of time, the role of environmental NGOs, and the UN Framework Convention for Climate Change, gives you some idea of how important these kinds of groups and actors have become. Third, the use of international law for global regulation. In the United States, we have made a very big effort to use trade law, which is part of international law, to get norms on intellectual property, things like copyrights and patents, normalized throughout the world and accepted by other countries. The US-Korea trade agreement, passed and signed into law by President Obama, put into place a number of rules governing intellectual property and copyright. So, for example, legitimate copying of movies, legitimate copying of texts and of novels and so forth, that are actually now part of Korean law at the behest of the US. And fourth, global justice and Chapter 7 of the UN Charter, which we'll discuss in the next lecture, where increasingly it's become seen as normal to intervene in conflict zones due to domestic violations of justice, as opposed to transborder ones. And the intervention into Libya and the ongoing debates about intervention into Syria give you some idea of how this works. Classically, intervention was only supposed to happen when one state threatens another. Increasingly, it's happening, at least it's being discussed, when one state threatens its own people. And, of course, you see this process going on in lots of other international legal instruments as well. The distinction between the laws on jus ad bellum and jus in bello, which were discussed here and there in your text, and which we'll get to a little bit later on in this class as well, give you some idea of the ways in which international law has focused more and more on the rights of civilians in conflict zones, on the rights of combatants who are taken in as prisoners of war. The codification of rape as a war crime represents a big step towards using international law to protect individual people, and the creation of new legal institutions, which once again we'll be discussing a bit later in the class. The International Criminal Tribunal in Rwanda, the International Criminal Tribunal in the former Yugoslavia, and the International Criminal Court are all going to go in hand with new understandings of what international law can do to protect individuals, and with new sets of responsibilities for the United Nations. What we're going to be doing in the next lecture is talking more specifically about the UN and how that institution has changed in response to these broader changes in international law that I've been sketching out in this lecture.